May it please the court, Your Honor, Natalie Miskell appears by counsel, Devin Seward.
Okay, I've got Daniel Gayer apparently on a separate Zoom. All right. Very well, counsel. This is a paternity matter. The court notes not only the contents of the petition, but also of the answer to the petition, which appears there is no contest regarding parentage of this child. Is that correct?
Yes, Your Honor.
All right. The court at this time can make a finding of paternity and essentially maternity as well, that the parties to this case are the natural parents of LM, a minor child. And further orders in this case would be appropriate as a result. I'll also note for the record that apparently Mr. Gayer was named on the birth certificate as the father, and Natalie Miskell obviously as the mother. There is no contest over the issue of parentage in this case, and therefore the court can make this a decree of parentage at this time. Now, with that said, what issues do we have? Mr. Vaughn, your views first.
Judge, I think primarily the issue is going to be parenting time in custody. Our position obviously is reflected in the temporary orders, with my client being the primary custodial parent at this time. My understanding is that they're wanting the same, but with the respondent being the primary custodial parent.
All right, Mr. Seward.
Yes, Your Honor. Hold on one second, Your Honor. We just had somebody come in the door, and our secretary is out having surgery. Do you mind if I handle that real quick? There's nothing been, gone through the courts up until now. Both parties live together. The baby was born in February, so it's, basically a newborn, less than a year old. So everybody lived together. They had a big breakup. The cops got called. My client got charged with domestic battery. Everything I've talked with her about, it was pretty flimsy. It sounded like the petitioner was the one who was drinking. She was trying to prevent him from driving to go get more beer. And that's essentially kind of how this whole case got started, the bad separation. My client got charged with domestic battery. She took a diversion to it. She's told me in private that she didn't actually hit him at all. So, take that for whatever it's worth. Because of that arrest, Mr. Gayer took the child and he, left and he went and lived with his parents. And so he's had the child this whole time. And my client came in and she's just desperate to get her child back and to have some sort of, solid parenting time. And, she works a night job, so she doesn't have any trouble. And she also lives with her mom, so she doesn't have any trouble with any kind of parenting time schedule. There's really no limitations. I mean, she's willing to watch the child at any time. So I don't know. I mean, our position would be that we would love to have, shared residential custody, potentially a week on, week off.
Guys, today we're stepping into a calm courtroom moment that quietly sets the stage for a custody fight no one saw coming.
There's a little bit of a distance between where the parents are living right now. And so that's kind of the biggest issue, I think, in the case is just, meeting somewhere halfway and having those exchanges. I think through the diversion order, I think there is still a no contact between the parties. And so that's something where, again, Natalie's mom is willing to help out as much as possible. So the maternal grandmother, she's willing to help out on all fronts to, make sure anything goes smoothly, and she could help do the exchanges if need be. Yeah, and so something we had an issue with. I mean, we're pretty much looking to modify the temporary orders today. I mean, that was the big one, was the residential custody within the temporary orders. They claimed that the petitioners had de facto primary custody. I mean, I don't know if that's true. I think both parties lived together, and they lived at the address that Natalie lives at now. So the child from birth until this arrest in October had lived at Natalie's house. And it wasn't until October, so a couple months ago, that it moved, residences. And then the other part in their motion was they put that um, he's the primary caretaker, and everything I've heard from my client is that she was the primary caretaker. She's done all of the raising of that child, the nurturing and the changing of diapers, just everything from what I've heard has been on her part. And so that was kind of the big issues that we took with their temporary orders, and we would just like a fair, residential custody setup, like a parenting plan that makes sense for both parties. I mean, I think you know, the relationship aspect of this case is over. I think the parties are not going to reconcile. I think they got to move on and try to co-parent. And so I think my client's willing to do whatever it takes to, help her daughter, and she's willing to she's going to put her daughter number one in every aspect of her life. And so with that, I mean, we just ask the court to give her as much time as possible.
Your Honor, if I may, there was one additional issue that I did not bring up to the court. We also requested that the minor child's name be changed. Now I know case law where we're at with that is that my understanding is unless parties stipulate to this court making a decision on the name change, I think I'd have to file a separate name or a petition for a name change. So I don't know if they're either willing to change the name or stipulate that this court has the authority and jurisdiction to make that decision one way or the other.
All right, Mr. Seward.
Your Honor, we would not stipulate to either one of those things.
I think you have the direction you need on that issue, Mr. Vaughn.
Yep.
All right. Mr. Seward has made a suggestion here regarding modification of the temporary parenting plan. Your response to that, Mr. Vaughn?
Judge, if there hasn't been any motion to modify on file, I know they filed an answer, but if they want to file or if they want to change the temporary orders, I think we need to have an evidentiary hearing on that.
Yeah, we did file a motion to modify.
Well, except, Mr. Vaughn, that your order was entered ex parte with no input from the other side, as ex parte orders generally are.
Correct.
Claiming that your client was the de facto custodian when apparently just because that there was an incident that separated the parties, he apparently just took possession of this baby and won't give it back.
Yeah.
Now in all fairness, Mr. Vaughn, and I think perhaps even going beyond what the ex parte order should do, he suggested, and this court adopted some way that the mother could have some court-ordered visitation with this child. But how old is this baby, born in 2025? How many months?
February, so about 10 months.
Yeah.
All right. Is the mother in this case facing any drug-related charges, or is she on any drug-related probation?
No, Your Honor.
Well,
So, Judge, just I guess to respond then, the issue is determining, okay, well, how do we establish de facto custody? Is it a week? Is it 3 days? Is it a month? At the time we filed this action, I believe that the child was in his care for about a week and a half, solely. So, I mean, that's the basis. We had a good faith basis for claiming de facto, but understanding the situation, as this court indicated, it is important to my client that their child see her mom. And so that's why we put that in there in our request for the temporary orders.
Mm-hmm. Understood, Mr. Vaughn. Understood. Um, we're not apparently looking at a situation where the mother abandoned this child, left this child to the father for him to fend day to day trying to take care of a small infant. The court has seen instances just like that, but that's not what we have here. Apparently, there was an incident that broke up these parties. The baby had to go somewhere. The father took possession, and that's the basis for the de facto custody in the case. But I think, regardless of what the temporary order says, and regardless of the situation that existed at the time the case was filed, we need to go forward from here. What's the most appropriate parenting plan going forward? Why would the mother be restricted to every other weekend visitation, Mr. Vaughn? What's the justification for that?
Well, Judge, we would dispute their characterization of the incident. The fact of the matter is, mom was arrested for domestic battery against the father when he was holding the baby in his hands. If the roles were reversed, I think it's, there would be, in most cases, there would be significant concern about an abusive father. Kansas isn't a preferential state as far as mother to father. So the fact is, we have someone who has stipulated on the record in our criminal case to domestic battery against the child's father. But as far as orders, I think it's appropriate that she would get holiday parenting time. Um, I don't know what that would look like, but this isn't a case where we're dealing with property. I don't think there's going to be a lot of witnesses. I would, I guess my request would be that we give her additional holiday parenting time and then set this for trial sometime soon after the first of the year. I don't anticipate issuing any significant discovery. I think, at least from my position, it can probably be exchanged by agreement of the parties to expedite it.
Oh. And in the meantime, your client holds all the cards. All right. I need an explanation on something in your petition, Mr. Vaughn.
Yep.
Assist the court, if you would. The petitioner, which of course references Daniel Gayer, and I'll just note that the court's not a big fan of lawyers' tendencies to refer to people in domestic cases as petitioners and respondents. I think orders and motions are hard to follow. Mother and father at this point seems appropriate, or perhaps just use the parties' names. But with that said, uh, petitioner filed a PFA against the respondent, which I am presupposing then means Daniel Gayer filed a PFA against Natalie Miskell.
The moment that changes the entire tone of the case. A serious allegation drops, and suddenly the stakes skyrocket.
In Greenwood County case number 2025 DM 50. However, no temporary orders have been issued in that case. So what's the status of this 25 DM 50 case?
Judge, so I do not represent Mr. Gayer in the PFA. My understanding is that court ordered those cases to be consolidated. I haven't seen anything come through on that. I don't know if that's something we need to do proactively by agreed order between myself and Mr. Seward. I guess I would defer to the court on that, but my understanding is that court wanted it to be combined with this case.
All right, so that court, the magistrate court, I presume,
Yeah.
declined to enter temporary orders, didn't dismiss the case, left it pending,
Yes,
hoping it would be consolidated with this one.
correct. And to my knowledge, it is still pending.
Okay, well, there's no conflicting order in that case. And it doesn't appear the matter is even going to be set for trial at this point, unless Mr. Gayer is aware of a trial date that's actually been established. It's your case.
Hey, Your Honor.
I'm sorry.
Um, so, hi, I'm Daniel Gare. So the case for the PFA was just temporary orders. It was just just in case until the no contact thing was figured out. It has been consolidated. It has been dismissed. At for the first hearing for the PFA, we were both told that she was supposed to set up supervised visits, and then we had a second one. Um, I can't remember the exact day right now, but it was dropped, and it was consolidated. My bad. Into now just going into this.
Okay. Well, that's news to me.
Okay.
So,
Judge.
I'm going to deal with the case which is properly before this court at this time, and that's 25 DM 51. I was just curious about the case history and status of the other case that could have resulted in conflicting orders with this court. I don't want to suggest for a moment, Mr. Gare, Mr. Vaughn, that you proceeded in anything but good faith here. However, the ex parte order is only meant to be an interim order until the court can make a determination, first of all, of parentage. And then once that's done, the court needs to make appropriate orders in the best interest of this child. We've got a 10-month-old baby, and I'm not going to have the mother begging for whatever crumbs Mr. Gaye's willing to throw her. If they have a bad relationship that resulted in some sort of domestic situation, maybe you guys need to be apart. Maybe your relationship's not working. This paternity case almost assumes that you're not going to co-parent this child in the same house anymore. So the court's going to treat mother and father at this juncture as equals from this point forward. The court's going to enter an order of joint legal and shared residential custody effective immediately. I'm going to require turnover of the child to Natalie Miskell at a date that Mr. Seward suggests. Is your client in a position to be able to take the child now?
Yes, Your Honor.
Okay. Well, I do want to have an orderly transition.
I think maybe Saturday.
Excuse me?
If Saturday would be work for everybody.
Okay. Mr. Vaughn, Mr. Gare, is there any problem with Saturday?
So are we looking at a week to week or?
We are,
Okay,
as modified by the court orders here in just a moment.
so if we're looking at a week to week, I would think Sunday or Friday would be appropriate just because, it breaks up their weekend. That way both of them have a full weekend with the child.
Is there any possible way we could do Sunday to Sunday? Or Friday to Sunday? All right.
Or leave it up to.
Well, I'm concerned about the period of time that the child's been separated from the child's mother, and I want to have that transition sooner
Yeah, if we could just
rather
do
than
them
later.
Yeah, Friday.
At this point, I'm going to order Friday to be the exchange. 6 p.m. is a normal time for exchange. And it seems to me that I think we're talking one parent in Douglas and one in Eureka. Seems like the midpoint would be El Dorado. That would be about a half hour for both parties.
Yeah.
I think the parties were meeting at was it the Shell station? Or not Shell?
It was the
Sinclair's gas station in El Dorado.
Okay, address?
Judge, I don't know it off the top of my head, but I think it's the only one in El Dorado.
No, there's two of them.
Oh,
It's the east side one, the second one.
Right there by the movie theater and the police station.
Yeah.
The east side Sinclair station in El Dorado, Kansas.
Yes, sir.
The exchange point, 6 p.m. And Mr. Gary, you need to be on time. Mr. Seward, your client needs to be on time. Neither parent should have to wait on the other. They should both be there at 6, make the exchange with whatever formula or diapers or whatever would be appropriate to exchange, clothing, coats, that kind of thing. I trust each parent has access to a car seat, an
Yes.
approved car seat. That's absolutely critical. And I do realize Christmas is coming up. So while the court obviously supports the mother having custodial parenting time in the very near future, the court also doesn't want to deny Mr. Gayer's side of the family an opportunity to actually celebrate and having the baby in the household as they do so. Obviously the baby's not going to be aware that it's Christmas as a practical matter, but it also doesn't mean that the rest of the family wouldn't want that child there. So the court's inclined to make an exchange, perhaps Christmas morning from mother to father.
Already have it established this Christmas Day.
Yeah, we already have an established time of day to do the exchange with Luna.
What time is that?
Christmas Day, 4 p.m.
Okay.
Okay.
I appreciate that, and the
Yeah.
court will make that the orders of the court.
Okay.
That, in essence, would probably be the effective start of the father's week, which is likely to be an extended week. With 6 p.m. on Friday exchanges after that point.
So am I picking? Okay, so if it's starting, I'm just asking. This Friday, she gets her for this week, and then Christmas Day, she'll be doing an exchange back to me.
Correct.
Okay. Okay, just making sure.
All right. Mr. Seward, I'm going to ask you to draft an appropriate order stemming from today. Begging the question here, Mr. Vaughn, did you want a separate decree of paternity
I think
filed
that'd be
independently
appropriate,
of a parenting
Judge.
plan order? Excuse me?
Yeah, since they're not stipulating to the name change issue or addressing it in this case, I think I'll need that.
All right. Mr. Vaughn, if you'll just draft the journal entry of determination of parentage in this case. Mr. Seward, you'll draft a temporary parenting plan order setting forth the exchange location, exchange time, and the week-to-week joint and shared custody schedule that the court has temporarily adopted. Probably the relations between mother and father are strained right now, but the reality is we need to just go forward from here and put any contention in the background and just do what's right for this 10-month-old, because none of this is the 10-month-old's fault. So we just need to make sure that that child is protected and cared for and co-parented in the manner in which it deserves. If you'll pass that message along to your client, Mr. Seward.
The judge takes control and flips everything. No crumbs, no favoritism, just a powerful ruling focused on the child.
Other issues can be sorted out with the assistance of lawyers later. All right. Mr. Seward, is there anything else that you believe we need to address currently?
I don't think so, Your Honor. I think that's everything.
Mr. Vaughn, anything further at this time?
Judge, as a procedural matter, I don't get in front of you as often. Do you require parties attempt mediation first before setting a trial, or?
Generally.
Okay.
Is there any possibility that just with counsel on both sides and these parents starting a co-parenting relationship on a joint and shared basis, that there might be able to be some negotiations take place before we get outside professionals involved? Your thoughts on that, Mr. Vaughn?
Judge, I've never met Mr. Seward's client, but my client, I mean, you've heard him today. He's I think he's pretty reasonable. So I'm optimistic. However, my only thing is I don't know if we could set that out, even if we're looking at mediation sometime in February. That gives parties ample time to try to resolve it, but then we're not needing to get back in front of court to get that set up if it's going to be in order.
I think what you're suggesting, Mr. Vaughn, is that if the parties would be ordered to enter into good faith negotiations, but if those negotiations are unsuccessful by January 31, then the parties are to participated in some sort of alternative dispute resolution, which apparently you're suggesting mediation?
Typically, Judge, unless you have a different preference.
Well, who do you have in mind to conduct the mediation should it be called for later?
Your Honor, I know Angela Meyer in Pittsburgh. I don't know over your way. Does Amy Ross? Does she? Trying to
I'm not
think.
familiar with that name.
Yeah, I'm trying to think of attorneys over. I don't get over to Greenwood County as much, so I'm not as familiar with that area. So if the court has a recommendation or someone they've used in the past, I'm more than willing.
Okay. Many of the persons who engage in alternative dispute resolution on behalf of the court office in places like Wichita. I'm trying to stay a little bit more local. Mr. Seward, do you have any suggestions?
I mean, I'm the same as Chase. I mean, I primarily work in Wichita. I mean, I have a list of all the mediators in Wichita, so I mean, I could send that to him, but you know,
Why don't you two at least confer over that? And, we have a little time before it would actually be implemented.
Yeah.
And determine if it comes to that, just kind of have a pre-arrangement as to who you both agree upon, perhaps with consultation with your clients.
Okay.
All right.
Yep.
Court would so direct. That more directly deals with the parenting plan than it does the determination of paternity. So, Mr. Seward, that clause regarding January 31st deadline regarding good faith negotiations to settle issues and mediation to start in February if they're not settled, if you could include that in your order.
Okay. Yep.
Hey, Your Honor. Just a question. So if both grandparents are there, are me and Natalie allowed to talk about discussing Luna?
You think that's necessary to have supervisors there before you two can talk about your child?
I think his concern,
No,
Judge, is
because
the,
of the no
criminal
con.
case.
Mr. Vaughn, I want to hear from Mr. Vaughn.
Oh,
Yeah, I think my client's concern, Judge, is the criminal case. I agree. Parties need to be able to communicate.
Does
But-
she have restrictions through the diversion agreement?
Your Honor, I'm not sure if she does. That's something I need to take a closer look at. I just know she's agreed to a diversion, and I think she acted like there was a no contact. But I'm not 100% on that issue.
Well, I don't want her to do anything that would be contrary to the terms of her diversion agreement, first of all.
Yeah.
So that needs to be checked out. But with that said, otherwise, maybe that's the best way for the parties to talk right now is to have somebody there to kind of supervise and stay out, but nevertheless just be there to make both sides comfortable. Your suggestion is not a bad one, Mr. Gayer, but I don't know what restrictions she might have in a diversion agreement. And quite frankly, I don't know why a criminal court would want to get involved in interference with parents who have the constitutional right to parent a child.
Yeah.
I do understand that they may need to have some restrictions on contact with each other, some reasonable restrictions on communication and conduct, but keeping them apart from one another makes no sense.
right. Thank you, Your Honor.
All right. So, Mr. Gayer, for whatever it's worth, I like your idea.
Yep. And Sam, if we need to sign something to modify any no contact order to nonviolent contact, I'm sure my client would be agreeable.
Yes.
Okay.
Well, thank you, Mr. Vaughn. I appreciate that accommodation, but again, there's apparently a county attorney or a municipal prosecutor's office that has to be involved in that decision as well. So, I appreciate the attempt at cooperation here. All right. Mr. Vaughn, anything else further at this time?
No, are we going to set a review date, Judge?
Okay, I was thinking that you wanted to try to avoid that necessity. I'm certainly open to it.
No, I think we can avoid that. I just didn't know if the court wanted one. Since we've got kind of a directive on trying to work this out and then looking at mediation. If mediation doesn't work, then I think at that time we could probably just set a date.
Okay. All right. Let me know if you need another hearing date on any issue, counsel, and we'll get one worked into the calendar somewhere. January and February are already quite busy. So no winter slowdown in our court system. All right. Jagger, I just hope that you work in good faith to just try to do what's best for your child in relation to working with the mother, and she does the same.
Absolutely, Your Honor.
Last but not least, Mr. Vaughn, I don't know whether your client wishes to indeed pursue the change of name.
Mhm.
If so, that action will need to be assigned to this court.
Okay. Yep, I
There
imagine
is
we'll be
a-
getting that drafted in short order, Judge.
If filed in Greenwood County, there should be party matching that would cause that to automatically happen. But unfortunately, as I understand it, the system needs to have such similarity between the parties identified in the system, or the computer won't know to assign it to the same judge.
Yep.
So often it can slip up. So, but it would be the intention of the court to hear the name change action as well, since it is at least related to this current action. Okay. All right. Very well then. That said, thank you, counsel, for your presentations to the court and your involvement, Mr. Gare. If there's nothing further at this time, then this paternity matter will currently be in recess, and this meeting may be ended for all. Have a good day, gentlemen.
Thank you, Judge.
Structure replaces chaos, and balance is restored. If you found this breakdown helpful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.